Hello, I'm Josh from Coventure Tax Consulting. Today, I'd like to talk to you about the tax planning options via incorporation for medical practitioners, dentists, vets, and solicitors. Traditionally, it was not possible to incorporate a professional business, but slowly rules are being relaxed and opportunities for tax planning are becoming available. Historically, most professional services were unable to incorporate. Even today, certain professions still face restrictions. For medical professionals, incorporation became an option in the late 2000s. The Medical Council has clarified that doctors can incorporate their private practices, but with a significant caveat. They cannot use a company to limit their professional liability to patients. Ever since, a number of doctors have elected to operate using unlimited companies, which enjoy the same tax benefits as limited companies. Incorporating a medical practice requires doctors to change their contracts and notify several parties, including their professional indemnity providers, health insurance companies, and the Medical Council. For dentists, the landscape is quite restrictive because of an arcane prohibition on the practice of dentistry by companies. However, full or partial incorporation can be available depending on the circumstances. While the Dentists Act 1985 prohibits individual dentists from practicing through a company, full incorporation is available for 2 or more registered dentists who are in business together. There are a number of legal issues to be straightened out, though, including the rights and responsibilities of each business partner, the rules of governance for the business, profit-sharing arrangements, and mechanisms for decision-making, dispute resolution, admitting new owners, retirements, and dissolution. For individual dentists, or those not ready for full incorporation, partial incorporation may be possible. This involves setting up a company to provide services that fall outside the legal definition of restricted services. For example, services like dental nursing, hygiene, lab work, and other non-clinical services could be incorporated. Let's define what we mean by restricted versus unrestricted services. A company is prohibited from engaging in the practice of dentistry, which includes any treatment or advice typically performed by a dentist. These are called restricted services and include things like fitting or fixing artificial teeth. However, services that fall outside the direct practice of dentistry, known as unrestricted services, can be incorporated. These might include the work of dental nurses, hygienists, or technicians. For instance, dental prostheses, such as dentures, are exempt from VAT, making them a common area for partial incorporation. Before proceeding with partial incorporation, it's essential to evaluate your income streams. This involves identifying the scope of unrestricted services in your practice, assessing the portion of income generated from these services, and reviewing the direct and indirect costs associated with them. This analysis helps you decide how to structure your practice efficiently. If you choose partial incorporation, you would set up a company to provide unrestricted dental services to your practice. However, it's critical to manage tax risks and organize appropriately. Of particular importance is to avoid VAT leakage. Correctly structured supplies of dental services by your company to your practice will be exempt. But not structured correctly, those same supplies will trigger a VAT cost to you at 23%. For vets, incorporation was not possible until the Veterinary Council relented to pressure from its members to allow incorporated entities. Vets are allowed to incorporate, provided all veterinary services are performed by registered professionals. Incorporation is not a straightforward process, and vets must ensure that the transition is handled correctly to avoid missing out on the expected tax benefits. It's also important to note that incorporation may not be suitable for every veterinary practice. Finally, let's talk about solicitors. In October 2019, large parts of the Legal Services Regulation Act of 2015 were commenced by Justice Minster Charlie Flanagan. This opened the door for legal partnerships to apply to be authorized as limited liability partnerships, LLPs. Authorization of a partnership of solicitors to operate with limited liability under the Act does not create a new business entity, and therefore it does not alter the tax structure or confer any tax benefits on legal partners. It merely enables existing partnerships of solicitors to limit their personal liability. So, solicitors cannot conduct legal work through a company, and while this restriction exists, they may not fully incorporate their legal practices. However, many solicitor firms offer other services, such as company secretarial work, which could be eligible for incorporation. Incorporation offers many benefits, including tax savings and liability protection, but the process can be complex, and not all practices will benefit from incorporation. Medical professionals can incorporate, but must navigate compliance reviews. Full incorporation is available for 2 or more registered dentists who are in business together. Veterinarians can now incorporate their practices, provided services are delivered by registered professionals. Solicitors are restricted from incorporating their legal work, but may be able to incorporate non-legal services. Incorporation offers many benefits, including tax savings and liability protection, but the process can be complex, and not all practices will benefit from incorporation. It is essential for professionals in these fields to carefully evaluate their specific situation, consult with tax and legal advisors, and ensure that they are complying with the applicable laws and regulations. Thank you for watching, and if you have any questions or would like assistance with incorporating your practice, please don't hesitate to reach out.